Welcome to the Secrets of Personal Injury Law with Colin Bober.
Hello and welcome to the Secrets of Personal Injury Law with Colin Bober. Colin is a personal injury attorney who has represented over 4,000 clients with a gross settlement recovery of over $50 million. I am your host, Kevin Rosenquist, and today's episode is maximizing your compensation, what attorneys do behind the scenes. Colin, welcome back.
Hey, glad to see you again.
Yeah, you too, man. So in your experience, what are some of the common tactics that insurance companies use to minimize payouts? We've talked a little bit about this, but it's always interesting to me to see like what their tactics are and how you fight back to ensure fairness.
Without naming any particular insurance companies directly, because to be fair, I think they're all equally bad. But one of the tactics that they've been using for a number of years, one in particular, is they'll take the medical bills of whatever a client went through and run it through software. It's called Colossus for one, and there are a couple other names to it. But basically, its purpose is to audit the medical bills based on their identifying ICD-10 codes, which are diagnosis codes to identify whatever the diagnosis is, and take them, and it takes the bill and either discounts it or unbundles some of the codes to calculate a potential settlement value and spits out a number. And so that's why we always tell clients when the first offer comes in and it's garbage, don't be surprised. That's their job. Okay. And what we find, at least in my experience, is that that's what they do. That's all they do. They feed it in a machine to throw out a number, and they don't actually look at the demand and what it says, right? It's called benchmarking. They put it through the machine, slaps out a number. It cut the medical bills based on what they thought was reasonable and customary for the geographic area, slapped on a couple $1,000s from general damages and called it an offer. But that's the fun part. I love it when they do that because it sets them up for failure every single time. Because usually when they throw out the number, instead of negotiating and throwing out the counter demand to try and get it settled, I'm like, all right, cool. I got your number. Walk me through your evaluation. And all they can tell you is, well, we just thought the medical bills were inflated and we just benchmarked them what we thought was reasonable and customary, slapped on $2,000 and called it off. Well, they did, but notice they didn't say anything about a potential traumatic brain injury. They didn't say anything about disc protrusions. They didn't say anything about pain management. They didn't even say anything about a hospital visit. They do it as a cost-saving measure, but it's terrible because all I have to do is get you to say something wrong, and then I just beat you over the head with it because it just proves you didn't read what I sent you in the first place, right? And that's the kind of leverage that you want when negotiating with an insurance company, because they have to convince you, the client, to take their settlement offer to indemnify and release the other at-fault driver for the rest of your life. And if you fumble the ball right out the gate, it ain't gonna happen. And so that's the first tactic that we use, not to make the first move. The person who talks the least in the negotiation wins.
Interesting. That's an interesting take on that.
Yeah, it's hilarious. Because I remember I had one. She, for an example, the adjuster sent me an offer, and she said, "Well, we're not considering the MRI because your client never complained of radiating pain." And so I went through the medical records because I sent the demand. I know what it says, but I just wanted to be sure. And I went through the demand, and it said she complained of radiating pain 14 times, which proved to me, like I said, that the adjuster didn't even read the demand. She just slapped on a number. Mm-hmm. And so after I pointed out that she was wrong and she felt really dumb about it, and I don't blame her, then she came with more money because I read the demand that I sent it. And the only way you're going to be able to get my client to accept your offer is if you negotiate with me in good faith. Because if you don't, I'm just going to tell you to go back, try again, and give me a different number based on the facts.
There's a lot of different critical pieces of evidence that you're going to look for when you're building a personal injury case. How hard is it to ensure evidence is preserved? How do you go about doing that?
Depending on the type of case, what we'll do is, especially when it comes to commercial auto cases, whether it's an Uber case, it could be a Domino's driver, or it could be, the big ones like an 18-wheeler. Typically, what we do, and you had asked in a previous podcast, how important is it to be quick and get with an attorney as soon as you find it reasonable to do so. We send out what we call a spoliation letter, which is a letter notifying the at-fault party to preserve all of this particular information that's listed so that if they destroy it, then they get in trouble by the judge. Right. So we send those letters out to preserve the information. That way, when we go into discovery and litigation and collect that information, we can look at it and see.
Can you kind of walk us through your process of how you investigate an accident to ensure that all the evidence is gathered to maximize compensation?
So we always start out with the police report. And then, of course, we all during the intake, we try and get as detailed a what happened in the accident from the client. I mean, something as simple as I was rear-ended, there's a lot more detail to that. Okay, I understand you were rear-ended, but I also want to know, did the driver say anything to you? Did you say anything to the driver? Did the driver get out of the car and did you smell anything on their breath or on their person to suggest that they might have been drinking? Do you have any reason to believe that they were on their phone and not paying attention when they hit you? And then, of course, do you have anybody around you that we can get phone numbers from? Because the police report may or may not even be available for 10 to 14 days, right? And so sometimes they're faster, but sometimes they're not. And so when you're doing your intake with the client, you're asking them all those probing questions to figure out, I understand how the accident happened, but I want to know the extraneous information early so that I know who to pursue. So for example, if the client said, yeah, you know what, as a matter of fact, the defendant got out of the car and a beer can fell out. This happened before, which led us to go background check the defendant and find out that that's his fourth DWI, right? And so now that opens a can of worms in turn for the insurance company to be like, that guy's going to make a really bad witness. If we have to go to trial, we need to settle, And so, or if the defendant was on her phone. Now we have another one that we're working on right now where the defendant was on her phone. Because she was on her phone, she rear-ended the client twice. She got hit twice because she just kept going, right? And so that's the information, because it's one thing if you get hit once, and it's another thing if you get hit twice. So the insurance company can't say, oh, well, we don't think she was really injured. Well, obviously she was if she got hit twice. And the same thing is true. If you get rear-ended and then you get pushed into the car in front of you, you were technically hit twice. So those are the kind of details that you want so that you know what evidence you're looking for to begin with.
Are you able to go after cell phone records? How can you prove someone was on their phone?
Well, no, most of the time, the defendant or the client will say so that they saw it. Mm-hmm. So their testimony is admissible, and you can request phone records, and the insurance companies do it when they send us their discovery request on our client for their phone records, and we usually don't give them to them because we don't, we usually settle it before that. But it's possible. You may have to fight with them to get it for privacy reasons. But it is possible.
There's a lot of experts that you can call, obviously medical professionals, and something I think has always been interested in is the accident reconstruction specialist. What an interesting kind of crazy career choice. But
yes,
can you talk about how these experts fit into the overall case and how much you lean on them?
Beyond the demand part where they just run it through the machine, the other tactic that they do is insurance companies think, for one reason or another, that the way the vehicle looks at the end of the accident determines whether or not the person inside it was actually injured, right? But here's the thing. Every vehicle comes with a bumper. The bumper is designed to absorb the impact.
Yeah, it's not like my mom's LeSabre growing up where it was like a tank and the bumper was like pure steel,
Right. And so, here's the thing. The tactic is clever until you realize that the bumper may look fine, but there's an absorber behind it. And if the absorber has to be replaced, then that means that the accident was pretty significant, even if the bumper looked fine.
Right.
But you won't even know that if the vehicle is not in repairs yet. Right. So it's just one of those tactics. So it's more so looking at all the information to make sure that the insurance company just doesn't say, well, it's a low impact accident. There's no way that your client could have been injured, because they don't correlate.
So how then does the accident reconstruction expert help you prove that wrong?
It's possible to pull the data from the car, from both cars in the discovery request. I call it a black box. I don't know if that's a formal term. That's what I call it because it makes sense to me.
I've heard it called that plenty of times. I think you're good.
So it will tell you if somebody honked their horn. It'll tell you how fast they were going. It would tell you how much pressure they put on the brake, all that stuff. So they pull that data and analyze that data to determine the impact and what that would have done in terms of G-forces to the body. Because here's the thing. These insurance companies, they say, well, the client, the speed limit was only 35. It couldn't have been that bad. But have you ever seen a crash test on a new vehicle? They also go between 25 and 35 and they smash the car. You can't tell me that just going under the speed limit doesn't create an injury, right? So they pull the data and they do models based on the motion of the body, based on all those crash test records to determine the severity of any potential injury.
So if an insurance company just gives you a terrible offer, just a settlement that you're not okay with, and you realize that's the last chance of settling and it's going to go to trial, what are the next steps?
So, in full disclosure, 9 times out of 10, the cases don't go to trial.
Sure. Yeah.
So, and there are a series of steps. So, if it's a case where the offer is completely unreasonable, then we don't negotiate, we just sue. Because what happens when we sue, we get a litigation adjuster who looks at it differently because now your exposure is higher and now you have somebody usually with more experience. When we do that, we may negotiate with them, but now litigation has started. So now we have the ability to collect additional information we weren't going to get before, right? So if we get a really low offer, that's what we'll do. And then after that, we'll do our best to negotiate, because also mediation is required even before you can get to trial. And after, in the discovery process, when the defendant, or actually both parties, the defendant and the plaintiff, get deposed about how it happened and what their injuries were, now all parties have all the information that, yeah, the original adjuster said that it was a low impact accident. But now, based on the testimony, yeah, we're insurance company, we're exposed, we need to pay. So it just depends on if the insurance company is willing to make a really bad business decision because they don't think it's related or that's severe. Okay, well then our business decision, the only one we can make is to sue, and that's the only way. And it's not meant to be a threat; it's just the only option.
It's your only recourse at that point. Yeah. And they're not stupid; they know that.
Yeah, and that's what they say that.
I imagine a lot of people, obviously, no one wants to be tied up in any sort of personal injury case or any sort of case like that. So I suppose there's probably a desire to end the case quickly, to move forward quickly by a lot of plaintiffs. Is it difficult sometimes to sort of balance their desire for it to go quickly with also saying like, hey, we got to make sure that we get you full compensation? Do you run into problems, or are people typically like, hey, as long as it takes, I don't care. Let's just get as much as we can?
It depends on what phase you're in. If you're not in litigation and you don't have to file suit, they want it over as soon as possible.
Right.
But as an attorney, you have to give them candid advice, meaning that you can have this thing over as soon as you want to. You can stop going to your medical treatment as soon as you want to. That's you. I'm an attorney. I don't give medical advice, and nobody at my office does. So if you're comfortable saying I'm good, I'm as good as I'm ever going to be, and your medical bills say X and your damage model says Y, if that equates to an offer that you're willing to accept, let's roll. If you're willing to cut your treatment short because you want it done yesterday, and you get a settlement offer that you don't want, even though you're still in pain, and then you come back to us and say, well, that's not enough money because I'm still in pain. What do you want me to do? I have to prove every element of my case, and you just cut me off because you want it to be over now, and now you're not getting the compensation you want because you didn't finish the process. So you have to have candid conversations with the client and make sure that they have the information to make their own decision as to what's in their best interest. And once you do, then they understand and like, okay, I only get one swing at this. Once I sign on the dotted line, it's over. And again, it's not meant to try and inflate medical bills or anything. It's just to inform the client, you need to prove all your damages, and this is the way you do that. If you want to cut it short, here are the consequences. You decide, let me know which one you're going to do. Now, if it's in litigation, they're more understanding because now you have to deal with the rules of civil procedure. You have a filing, and then they have to answer within 20 days after they answer. After service. And then we go through discovery, and each side we have to wait 30 days to send that out. So there are formal deadlines that we have to meet in order to even get to where they want to be. And so a lot of people in litigation understand that once it's in that process, it's kind of out of our hands in terms of deadlines, and they're more patient. But my job is to explain it in a way that they understand it so they can make a decision as to whether they want to go through with that or if they just want to take the settlement that they have.
How important is it to not talk to the insurance company, the other insurance company, when you're the one involved in an accident? I believe we've talked about this before, and the insurance company will, before you get counsel, they'll attempt to reach out to you and get a statement, right?
Sure. Yes.
I mean, everything I've ever heard is don't talk to them. Right?
Correct.
I mean, are there things you have to say? Are there things you have to give them the time of day at least, or can you just be like, sorry, no, and hang up?
Well, assuming that you're not represented, if you intend to be represented, I wouldn't say anything. If you're truly not injured and you just want to get your car fixed, talk to them.
Okay.
But if you're truly genuinely injured and you need care, don't talk to them, because they're going to try and make it seem like, well, I got pictures of your car. It doesn't look that bad, so we'll give you $500. But as we just described, property damage is not a direct correlation as to whether somebody's injured.
Yeah, for sure.
Right? So it really depends on what your needs are. If you're not injured and you don't need representation, go say whatever you need to say to get your car fixed.
Right.
It's the people who need care and representation that should not say anything.
Okay. I'm glad I asked that. That's a good distinction for sure.
Yeah, because we only truly want to represent people who need representation.
Right.
We're not trying to make fraudulent claims or anything like that. We just want to help people who need it.
Yeah, makes sense. All right. Well, thank you for tuning into The Secrets of Personal Injury Law with Colin Bober. To connect with Colin and his team, visit boberlawfirm.com. And please like and subscribe to our channel and leave us a review. Colin, it's always great chatting with you. Thanks so much for being here.
I can't wait to see you again.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.